Welcome to the Hipaa Privacy and Security discussion for Specialty Eyecare Group. This presentation is going to go through what the Health Insurance Portability and Accountability Act of 1996 is all about, and work through how we interpret and how we utilize it in our practice. Huge pieces of legislation encompassing 5 titles and 10 major issues, only one of which is directly related to the application of a HIPAA to a doctor's day-to-day, the Administrative Simplification Compliance Act. And it's been amended many times over the years. In layman's terms, this whole issue takes on 3 different things. It issues unique healthcare identifier numbers for individual physicians, health plans, and health plan providers. That's the NPI number. Standardizes the way medical records are transferred by any means, and mandates the security standards to protect the confidentiality of individually identified personal health information, or PHI, for past, present, and future. So it's the NPI, the security rules, and the privacy rules. Do people really complain about HIPAA? Absolutely. There's been an increase in complaints, especially since 2010, and the volumes have increased by 300% 2015 alone, and will likely be more once it comes out what the reports are from 16. Most complaints come from whistleblowers who are usually unhappy patients. So why the increase in activity around HIPAA? The law provides, the HIPAA law says providers are liable under the rules if they know or should know them, and ignorance is not an excuse. Willful neglect or ignoring carries severe penalties, and there's no grace period. Prosecution, fines, and jail time can be levied against individuals responsible for the violation, whether that person be a doctor or even one of our staff members. So it's very important that we understand why we all have to be HIPAA smart. So let's get started. So the National Identifier Rules, the Transaction and Code Sets, Privacy Rules, and Security Rules are the 4 main parts of the Administrative Simplification Rule. The National Identifier Rules is the National Provider Identifier, or NPI, and it was adopted as the standard unique identifier for healthcare providers. We would debate on whether it's simplified things. And then the Transaction and Code Sets, that establishes an electronic code system for all of the medical record documentation and defines what the content of a medical records are or were legally. So information that's considered private, per the Act, it's all medical records or other individually identifiable health information used or disclosed by a covered entity in any form, whether electronically, on paper, or orally. And this includes data that's at rest or in transit, whether it's past, present, or future. So specifically, it's the name of the person, all date elements related to a visit per se, email addresses, the medical record number, a license number, biometric identifiers, geographic subdivisions, telephone fax numbers, social security numbers, health plan numbers, vehicle identification numbers, and photographs. And any other unique number or characteristic or code that could be potentially used alone or in combination to identify an issue. So the big issue is the privacy rules, and there's 2 different types of disclosure that we have to deal with. Routine disclosure is what most of us do on a day-to-day, and this includes medical records, faxing, email, lab orders, etc., and what we are concentrating on. So non-traditional disclosures is anything not routine. For example, legal issues or life insurance information or research information that we might utilize in doing research. The privacy rules require consent to release certain information, and these, but we can have consent of the patient to allow the provider to release or disclose health information, and it is not required as long as the release or disclosure is related to the treatment of a patient, the payment issues, or healthcare business operations. So we refer to this as the TPO, the treatment, the payment, and the operations. And so there's things that are generally included in this, and that's the treatment in the office, discussing care with consultants, making referrals to other doctors, writing, sending, filling out prescriptions, preparing and submitting bills, receiving and posting payments, collecting efforts, professional licensure, quality assurance efforts. So essentially what this means is that within the office, if we're talking about a patient or we're discussing it with a consultant or we're referring a patient to another provider, there's consent that's essentially given by the patient that's not necessarily, verbally discussed, but it says that we have the ability to send information about the care of a patient. Others might be financial audits and management, so somebody's coming and doing auditing, the training of our team, office management, fraud and abuse prevention, disclosure to business associates, disclosures required by state law, to the FDA, and disclosures in response to court orders or subpoenas, and even more, notes related to psychotherapy, special rules, disclosures related to possible disease, injury, disability, child abuse, neglect, crimes, or domestic violence. And these have some very complex regulations around them. Disclosures for tissue donation, for marketing, and those are very complex, and for research, which is also very complex. So with regards to the TPO, does that mean that HIPAA doesn't apply? No, it's the area of confusion. It's TPO is a consent issue, not a privacy issue. HIPAA just says that the patient, by asking us or you to take care of them, has implied consent for transmission of healthcare data, but we still have to protect that data. Meaning if we're emailing it, we need to do it in a secure way. In general, what must we do to comply with the privacy rules? Well, we need to designate a privacy officer and a public information officer, develop policies and procedures on how medical records are handled and transmitted by any means. We need to meet all documentation guidelines, provide initial and updated training to our team, establish systems to handle any break in privacy, and establish sanctions for employees who violate these policies. So, how do we educate our patients? In order to be HIPAA compliant, we have to notify our patients of our privacy practices. And the NPP is a form that details the privacy policies of Specialty Eyecare Group, and it informs our patients of their right under HIPAA. And it contains the policies specific to SEG and may be different from policies of other practices. We need to display it and give a copy to anybody who asks for it. Every employee is required to read and understand our NPP. Now, patients need to acknowledge that they have had the opportunity to receive it. And this form is a document that we have and that we've attempted to inform each of our patients what the privacy policies are at SEG and make sure that they understand that they can have a copy of our NPP if they wish. And every employee at Specialty Eyecare Group needs to understand and be able to communicate to patients what our ANPP says. So how do we comply? Well, every patient will need to verify that they understand and agree to the policies of the acknowledgement of notice of privacy practices. It's best that we do this in writing. And if the patient refuses to verify or agree with an ANPP, then at SEG we will not agree to provide care for that patient. Now, there's basically one exception. If that's the patient presents for emergency care and the time or condition of the patient prohibits the patient from reading and understanding the document, then we may give care, but we want to make sure that the form gets completed at the earliest convenience. So, what specific rights does the patient have regarding our privacy policies? And the patient may refuse to verify and agree to the ANPP, and then they can seek care from another provider. The patient may inspect or ask to receive a copy of their healthcare information. The patient may request amendments to their healthcare information. That's a very sticky one. And the patient may make a reasonable request for individual confidentiality accommodations. More rights are: the patient has a right to an accounting of all disclosures by Specialty Eyecare Group. These would be only non-traditional disclosures. The patient who feels that their privacy has been violated may file a complaint with the privacy officer or myself, Dr. David Kading, the Office of Civil Rights, or the State Attorney General's Office. And the patient has the right to be notified if our policies substantially change. All patients' requests regarding their rights will be handled at Specialty Eyecare Group by our privacy officer. So what if a patient asks for their medical records? And patients are entitled to a copy of part or all of their medical record, not the original copy. Only a judge can subpoena that, and our original copies is digital. Request for information in a medical record to view or to copy. Those should be made in writing to the Public Information Officer at SEG, but it's not a requirement. And Specialty Eyecare Group may charge for copies of medical records at 15 cents per page. For diagnostic test results, instrumentation that we have in the office, we may only provide a written summary of the test results at a patient's at the patient's discretion, and what that means is that at first we're able to just provide them with a summary. We don't have to print out all of the documentation from all of the instrumentation. Can we deny the release of records? Yeah, if the information is in preparation for a lawsuit involved in an ongoing clinical trial, which being in research, it could be damaging to the patient or someone else, or the information is not part of the actual medical record. But we can never deny it because the patient or their insurance company or payer owes us money. So what's an authorization? Authorizations are required when the release or disclosure of healthcare information is for non-traditional purposes. This could be for pre-employment physicals, driver's license, information for life insurance, employment eligibility, for certain marketing purposes, or psychotherapy notes. any other reason the patient feels is a non-traditional disclosure. So authorization rules. So the company that we work with that deals with HIPAA, they feel, and we would agree at SEG, that the release of any information to a third-party payer that is not related to the service that the payer covers and is not needed to adjudicate the claim then is a HIPAA violation without specific patient authorization. So an example would be if a patient has a vision insurance and we provide that vision insurance requests, and we provide information to them about a diagnosis that isn't related to vision. That's information they don't need to know. And at Specialty Eyecare Group, we will not release such information without patients specifically asking us to. So marketing, when HIPAA does not define marketing as simply relaying information about our practice to our patients or potential patients. In fact, true marketing is releasing or selling patient information to a company for marketing purposes. True marketing requires individual patient authorization. It can't be a blanket office policy per the NPP. The privacy officer and or myself at Specialty Eyecare Group are aware of the HIPAA marketing rules, and we do abide by them. Posting on social media is something that we have to be very careful of, and we abide by very strict social media policies, and that if we are going to post about a patient, they must give permission before any image is posted, and they get that by signing a waiver. There's something that's called the minimum necessary requirement rule, and that states that a covered entity must make a reasonable effort to limit the use of disclosure of and request for personal health information to the minimum amount of information necessary to accomplish the specific task. Meaning, we don't need to give the entire chart record for the entire patient visit in order to order a contact lens. Incidental disclosures are routine actions that do not or are not intended to disclose any pertinent medical information to anyone other than the patient. So this would be things like sign-in sheet discussions of our doctors or our team in hallways, discussions with patients in semi-private settings, procedure logs, or calling a patient's name out in the office, or a patient potentially seeing a list of other patients. They're not a violation as long as we do what we can to take reasonable precautions against it. So what that means is we're not violating HIPAA by having a conversation in the hallway if somebody walks by. We just need to make sure that we're very cautious in what we're saying or how we're saying things about patients. And if we have the door mostly closed and we're discussing something with a patient, it's not a HIPAA violation if somebody walks by and may overhear a portion of that conversation. We want to do everything we can to avoid it. But likewise, if we're sitting in a pre-testing room and a patient walks by and sees another patient or overhears us saying something to the patient and it's in passing, that's called an incidental disclosure and is not a violation, but we need to take reasonable precautions against it. We do have business associates, and they are individuals or groups that render services to Specialty Eyecare Group or may have access to the practice that may have exposure to a patient's personal health information, but they have no reason to have access. They may include subcontractors of our business associates as well. So we need to have a business associates agreement, which are contracts where certain individuals who do business with our practice agree to our privacy policies. And we work to obtain these agreements from all individuals who fall under the potential designation of a business associate. Those would be individuals that may do medical type of business with us. For example, a billing service or a contact lens service or a laboratory who may have the patient's name, may have the patient's date of birth, and is making something for the patient on our behalf. So we're essentially on behalf of our practice doing business with these organizations, and we need to make sure we maintain privacy. A breach are unintentional or illegal release of a patient's personal health information, and breaches are defined, or the definition involves the extent and type of information released, how probable the compromise to the PHI could harm the individual, and how likely the person who obtained the information could use it in a malicious manner. The bottom line is that we'll handle this and contact an attorney if necessary, and if any staff concerns regarding breaches or if one should occur, we want to have you contact our privacy officer and Dr. Dave Kading. So what if a patient wants to file a privacy issue complaint? Well, we encourage all of our patients to come to our privacy officer and or myself, Dr. Dave Kading, in writing and have their concerns resolved within our practice. And we'll make every effort to resolve their complaints internally. But complaints may be made in writing to the U.S. Department of Health and Human Services, Office of Civil Rights, and to the State Attorney General's Office. All of these things are not good, so we would prefer for them to be internal if we can. The next area of HIPAA relates to our security rules. And how do they differ from privacy rules? So privacy are clinical routine practices, business practices around a routine, access to personal health information, and our behaviors, whereas security are physical barriers, technical barriers, data storage protection, and recovery after or within a disaster. So security rules are covered entities that must maintain administrative, technical, or physical safeguards to protect the confidentiality, integrity, and availability of information in a patient in an electronic format that they maintain or transmit. The security rule requirements require us to appoint a security officer, conduct a risk analysis to determine the threats or risks in our operational systems, to complete the organizational requirements, that documented policies and procedures for complying with all applicable security standards. Documentation requirements, risk analysis, and the management. These are serious. There's a series of potential concerns that we have analyzed in relation to our individual office operations, the locations and types of hardware, software environments we have in operations. The risk analysis identifies any potential risk or violation of security issues, and the risk management sets a plan out for how to deal with the risks that we may have. The compliance with the security rule is that we must and have addressed all security issues as they relate to Specialty Eyecare Group. These are administrative procedures, our physical safeguards, technical security safeguards. And there's 42 of them. Examples of what they are might look like the following. Security management process. These are covering our vulnerabilities, plan for risk management, and so forth. And there's many of them that include, things like virus or spyware or malware, and also things like transmission security, like our encryption. So some frequently asked questions is, do we have to contact all of our patients to inform them of our privacy policies? And the answer is no. We have to inform them if we make any significant changes in our privacy or security policies, or if a breach in our security occurs. Can we use patient sign-in sheets, procedure document sheets, or have an open greeting area? Yeah. But we want to contain as much information as possible, and our NPP states that our business functions in this manner. So can we leave a file or a document in some sort of receptacle around the office while a patient may see it? Well, we can, but we really want to maintain that that area is supervised and that the file's turned around or has some sort of protective cover on it. Can we call out patient's name in the reception area? Yep, but we want to use only the patient's names, no other identifying information. We wouldn't want to say Mrs. Catherine Jones, date of birth, vehicle identification number, yada yada. Just stating their first and last name, or Mrs. Jones, is how we want to do it at Specialty Eyecare Group. Can we contact patients using email or text? Yes. But we need to abide by strict regulations. We inform our patients in our NPP that we do this. Can we use faxes? Yes. Ideally, we would be using a fax cover sheet that clearly is visible. It contains a confidentiality statement, and our fax machine is kept out of general view and is not accessible by patients. Stating something like this on the fax is, if you receive this fax or email for that purposes and are not the intended recipient named above, immediately destroy the fax material and contact the center. Can we leave messages on answering machines, either physically or with a computer-assisted call program? Yes, but the message cannot relay any information about the patient's personal health information. It can only state the reminder of an existing appointment, that their eyewear is ready, but we would not want to go into a detailed explanation of the patient's health information. So what if a parent or somebody else drops off a child or teenager for an exam and they can't sign the MPP under Hipaa? Do we treat them and get the form signed later, or attempt to fax the patient? At Specialty Eyecare, we will see these patients, these children. If we must see them, we'll make every attempt to get their guardian to sign an acknowledgement for them as soon as possible. We may call the parent and say, hey, we need you to come back and sign the document, but we're not going to withhold care from a teenager or a child if we can later on get them. For adult patients, as defined by law, whose parents are still footing the bill, college age, or who are on their parents' insurance, do we need to have those kids sign an authorization allowing parents access to payment and treatment information? Unfortunately, yes. If they are an adult, the rules of authorization apply. So mom calls about their 19-year-old son's glasses, wanting to know what he spent so much money on while he was in the office. What can we tell them? Nothing, unless we have authorization. If we know the parent is footing the bill or might request information, we might want to ask for the authorization up front. Can we talk to family, friends, or caregivers about a patient? Yes, but only if we've obtained an oral agreement from the patient, or we infer from the situation that the patient's consent to this disclosure, such as a person in the exam room with the patient. Or we have a document, a power of attorney, or we use our best judgment to determine talking to other individuals is in the patient's best interest. Well, what about in-person release of information? We generally do not give any information to anyone in person except the patient, unless it is someone involved in the care or unless the patient approves. We can allow a patient's representatives to pick up a patient's glasses or contact lenses because our NPP states the patient's consent to do this is our business practice. But in both cases, phone and in person, the minimum necessary information rule always apply. We cannot relate to the patient's representative anything about the patient, their vision needs, special features of their glasses or contact lenses, or anything about the health of the patient's eyes. If a contact lens dispenser calls in for an RX and we don't have an ANPP from the patient yet, do we have to get one? No, this is a TPO, but as usual, we need to confirm that the request is really coming from the patient. Can we obtain payment from parties other than the patient, spouse, guardian, collections? Yes, fortunately, this is related to the TPO and is permissible. But, again, minimum necessary information rules apply and cannot relate information about what specifically is being paid for. So we can't go into and explain this is what the procedure was, why we were doing it, etc., etc. Do employees have to sign an actual statement of adherence to the office privacy and security policies? No, but it's considered a very good idea, and we do have all of our employees sign such an agreement, ideally within 1 week of being hired. And the final compliance issue is the privacy officer and/or Dr. Dave Kading will routinely monitor any changes in privacy laws and standards and make adjustments or additions to the policy as needed. All Specialty Eyecare Group employees will be promptly informed of these changes should they occur.